Hello, loved ones. Welcome to tonight's event. This is going to be a fast-paced one because I'm being challenged by the queens that, Darren, you have 70 questions. You better do something about it. So that's why we're here. To get the ball rolling, though, I wanted to just talk about these for a moment. The cards that were making a little bit of a disturbance in the force amongst this. Why are we doing this? This is a mechanism to direct your immediate thoughts, emotions, spirituality, all of it into a focused little laser beam. That concentration of energy gets things done. The cards are a manifestation of a state of your mind at the very present moment, again, right? So because you're actually bringing things into existence through these cards by being mindful. So when you go into these cards with the intention that all the information, wisdom, truth, knowledge, justice, all that stuff may be brought unto all yourselves and myself even, right? In the most effective method as possible. And may it resonate with you until the next term of events such as this. But because we're using these cards to merely focus our intentions, it's that laser beamingness. Again, you walk into the woods with just a dimly lit flashlight in the middle of the night, right? Like you're not going very far. The more energy we can put into that beam and the more we can focus it, the farther we can see. The cards literally are just it's a window or a doorway that's forcing us to start thinking like this. If you are skilled and you don't need cards because you're mindfully present about these elements, I'm going to say 21 hours of your day, then you know what? Set the cards aside. But for most of us that aren't at that level, we just need little reminders. Hey, I'm going to go pull a card because I feel awesome. Hey, I'm going to go pull a card because I don't feel awesome. You know what? And I've been shuffling these ones for about the last 15 minutes. And this is the one that we're going to look at. What does this one say? Romance angels are helping you. Well, if we're dealing with romance and love, and truth and honesty aren't far behind those two, you know what? I'm thinking this is going to be the path, is it not? It's absent personage. For starters, check that suit into the closet. Don't wear that costume all the time, only when you absolutely need to. Romance angels are helping you. Yeah, you know what? I'm down with that vibe. Absolutely. Again, the other element here about trying to bring the women's input and their spirituality and all the things they have to offer instead of them being swept under the rug for the last 6,000 years and probably even further than that. You know, think back in history to a handful of women that have made a difference. Go ahead, name them. You see how you start to struggle after 2 or 3? What Joan of Arc, if you want to talk scripture, okay, Mary aside and things of this nature, but I'm talking about just things in our relative recent collective memory. Mother Teresa, things of this nature. So yeah, compared to men, you could just go down the list, right? So we're trying to bring this elevated consciousness. We're trying to get women's contribution into the game because we are much stronger with them with us than them against us. And always dismissing us and, honey, go cut the grass, quit watching Darren's videos. Bringing these two elements in alignment is going to greatly improve how far we can send our laser beam of love here, loved ones. Okay, and the other thing with the cards here is I'm always trying to be, focused with everything I'm doing. And here's a perfect example of it. I haven't looked at any of the 70 questions until I sat down, and I'm looking at the first handful of them right now. So without further ado, I think I got the other stuff covered, really. And again, thanks for everybody showing up again without the usernames. I can develop a much better connection with you rather than, an acronym for a name. Okay, here we go. Who are the 144,000? Who are they, and why does Divergence keep referring to them? I'm going to suggest 144,000. This is from scripture. We got 12 primary tribes. I'm going to suggest that there's probably 12 shamans within each tribe. Now, this is going to expand from there. Those numbers are going to fill a void where this 144,000, these are either women and men that have overcome and have found righteousness post wrongdoing and are capable of not wrongdoing to the best of their ability, so that, you know what, okay, this is the difference between someone consciously putting a Facebook video up about, yo, I'm going robbing, and then that guy goes out and robs a house and gets shot. Okay, I'm talking about expressing loving intent, not I'm going out robbing, yo. Probably not of the 144,000 caliber. Do we love him the same? We're supposed to, so do your best, because it actually matters. We keep referring to them because we're at a fixed point in time where if we don't have a certain amount of ducks in a row, if we don't have a conscious effort being put forward as to, at least, okay, so we had scripture, it's a menu, it's trying to tell us a message. We took your message seriously, Creator, and it told us to be accountable to the 144,000. Now, I know there was a mention on here the other day about, oh, that's a Jehovah's Witness thing. Well, not really. Jehovah's Witness really embellished on this, but it's in scriptures. It's not a Jehovah's Witness thing. It's just this particular group of special people are supposed to rebirth, come to a whole new appreciation of life, and come into an incredible amount of resources and ability. I don't want to call it power anymore. Let's just call it ability. So people come into a tremendous amount of these resources, and it was up to them to spread the wealth that Creator has bestowed onto us, all the gifts. Can you expand on that, please? Okay, I think I did. So if one uses a private process for NOIs, etc., via registered mail, and a trespass does occur, does one file into civil court with a civil claim? Yeah, that's absolutely one way to do it. Using the private process, I'm going to suggest here that you're privately sending mail to a party, trying to give them notice of your, hey, this is me now, and I'm not going to act in person type paperwork. And then let's say that the bank still calls you back and demands the $30,000 you owe them for the credit card, and they're still hassling you every day. If they're still hassling you, it's a good indicator that your NOI or the registered process or something in here hasn't immediately taken effect yet. But give them some grace, like give it a grace period. If you get a call 3 days after, you know what, don't come out of your skin here. Their system that they're dealing with is so vast. It takes a lot to have the thing completely crank over once, like in your favor. And again, this is all dependent upon who do you send that notice to. Now, I'm going to suggest if you're sending it to the Attorney General or the judge, either of these parties is going to be very, very, very favorable. Again, framing this document, we're going to show you again Darren, how do we frame that suit? Well, framing the suit, right? We're going to, a particular suit for a such and such. And if we don't follow the styling of what would be included in a suit like that, the judges can bounce it because it's quite not maintaining or serving or furnishing the means of a proper case. We don't just roll into court with 1 or 2 sentences. No, we need to be just a little bit more expansive than that. And again, this is attributable to our knowledge, our skill sets, and how much time and energy that we've put into this. And this is what the judges are looking for. And the trespass does occur, but you know what? Forgive them of their trespass. Even if a police officer walks up and punches you in the face, forgive him. And you know why? Because you should have been on this a week earlier or earlier. We've wasted a lot of time. And believe me, I know Dean and I and many others have been doing this for a large portion of our adult lives, but you know what? Trust me, there was wasted time in there when I was doing something when I could have been doing that. And I wasn't, right? But there has to be some flow here, loved ones. Otherwise, you kind of get pulled apart. So you got to be able to balance this whole equation. The meditations, here's where you're going to find your balance from. Go into it, ovaries and balls deep, 25-8, as in the step above 24/7. Keep that going all the time. Just inject the meditation times. Look to that as your salvation. That's the only time that you're going to be able to recalibrate, get your messages, and find the power, the strength, and the courage to continue. Pretty important stuff. If one, let's see, okay, so filing into civil court, yeah, once you get into the process here before a judge or a magistrate or a registrar, again, believe me, loved ones, when they see, okay, how do you frame your paperwork? A suit to enforce a trust. Boom, as soon as the registrar sees that, they know, okay, I better treat this one with a little bit of respect. Because judging by the contents of some of this paperwork, these folks, they're almost speed readers. They know exactly what they're looking at. They go to particular parts of the process and boom, 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 they're checking boxes and stamp. And if your cause is an emergency or if you made it under an urgent circumstance, she can literally go take it to a judge. She's going to come back and say, okay, the judge can see you in 15 minutes. Are you ready? What's your answer? Shit, no, Darren said this was going to happen at the kitchen table. Right? This is why I was trying to pound into everyone's heads here that, you know what, let's consider this whole process as we are going to court. That way we're never fearful. If we just met that fear head on and say, hey, I'm going to the top. Once you get to the top and you appreciated that, you took it seriously, you prepared as if you were going to court, well, guess what? Now you're competent. Now you're confident. You haven't half-assed nothing. So I encourage you to still have that in your mind of going to a judge. Although here's how this is really ought to shake out. We send our stuff to the Attorney General with a special written agreement. This special written agreement sets the stage for a whole bunch of awesome shit. So that now you are actually coming in the name of the state, but through the Attorney General's office, you're at arm's length of this thing. This is what the trust does. The trust is its own entity. This thing, it exists. And I wouldn't even suggest that you technically own the trust. Nope. Once you create this thing, it's a life form of its own. Imagine you created your children, yes, but do you own them? Not really. They're autonomous. So is a trust. So is a corporation, but you'd write a corporation and trust. I mean, yeah, they're similar, but trusts are for a whole different purpose. Filing into civil court, yeah. As soon as the registrar sees that, you can get some instant relief right away as soon as you bring this stuff in the court, depending on the severity of the trespass. If the bank is calling you, I wouldn't call that an emergency to get your chambers hearing. But you know what, Your Honor, I believe that there is a warrant for the arrest of this person, and I'm coming forward with clean hands to deal with this and bring this to your attention now. Things of this nature. Now, I'll be honest with you, equity doesn't like getting involved in criminal matters. Once criminal matters are set, they're kind of set. However, get caught and then whip out your trust indenture and say, haha, officer, you have to let me go. No, that's not how this fucking works. Okay, so filing it into private court, yeah. Again, as soon as they see a trust indenture, as soon as they see a suit to enforce a trust, guess what? You're on the equity side of the court by default. It just happens. You don't even have to technically motion to seal the court at this point, because the clerk can already tell in the first, I don't know, this much of your paperwork that you know what the hell you're talking about, and she'll literally seal it automatically. Is the BC an estate title to a trust of land? Is the birth certificate an estate title? Yeah, once it's converted to a trust of land. Yeah, the trust of land is a result of that conversion. And is it treated as a mortgage if we declare it to be one in equity? Absolutely. Is the pledge of the body and its earnings into the Crown Trust considered as a trust deposit or not? Yeah. Problem is that trust deposit was made generally by our parents and then abandoned right afterwards. Oopsie doops. Let's clean that up. Identify the deposit. Well, now we're coming with a special deposit this time. Nothing general. We don't do anything generally at all. Again, so remember we had that implied contract, that implied trust in the beginning with no consideration, no mortgage terms, no agreement, no F all, naked. This is what they call a good and marketable title. Yeah, for them, not for you. But here's the beautiful part. Here's the saving grace. They took it upon themselves. They enriched themselves, but in doing so, they furnished the value and the commercial ability of your certificate being specially deposited. They've gone out and earned a whack of income through this little certificate that happens to be in your best interest if you declare it to be. So yeah, new trust, better deposit, whole different set of scenario. We're trucking now. By endorsing the birth certificate, that simply starts the process. Yep. Before sending it back and or appointing a new trustee, what is the purpose of endorsing? 2 signatures have to be present on a written agreement to prove the agreement. If there's one signature, 2 parties, we don't have an agreement, right? Put your signature. Okay, go everyone look at your birth certificate when you got a moment. See that little space where there's their signature? Put yours on top of it. The state, is underwriting your position. It's like you're up here, they're the undertakers. Plus, I'm referring to the adverse claim now, of course. I know we did sign on the other side as well. You know what? You can have two things stipulated on both sides of that certificate if you want. Again, I just punched one up for Jody here a few days ago. We'll get into that in a little bit. Dealing with a bank situation. Okay, so here is where I put two signatures that you got agreement. Once you got agreement, this is over. This is the beautiful thing, loved ones. They're technically giving you a blank negotiable instrument, which they've already agreed to, and they've put it in into your possession so that you can go do something with it. This is you accepting. When you put your signature and you endorse it, that's accepting. That's changing the entire flavor of the agreement. And as such, now you're coming forward because you're bona fide. Now you're the protected purchaser. Throw a whole bunch of other intent on top of it. Bake that cake, Your Honor. What do you think? See? Substance. So that's why we're endorsing it. Forms of endorsing. Could I put an X on it? Yeah, if that was your intent, sure. Could I only put a thumbprint on it? Yeah, technically. As long as you sign an affidavit saying, yeah, that's my thumbprint on there, because that's a little obscure. You just got to explain it somewhere, right? And it'll fly. On the back of the birth certificate, it reads void if altered or laminated. Is that a problem? Here's the perfect example of how we should be reading these sentences with equity eyes. Whenever you see the word or, literally close that book and in your mind, open up a new one, because or completely changes the dynamic of the substantive nature of the statement. And here's why. If your birth certificate is laminated, you can't write on it because someone could just come off and wipe the ink off. That's why it would be void. Here's the interesting thing. When we do put some ink on it with intent and purpose and guess what we are actually doing to it? You're actually voiding it. We're making it void at the end of the day. Why? Because that particular certificate was issued for a specific purpose, correct? At the end of that thing's life term, it has come to the term of its whatever it was supposed to do. Now we are actually going to void it. It's actually going to go be canceled in the background by the vital people. The vital people are going to cancel this one and issue a new one. So technically it does get voided and canceled. We want it void. Another way of voiding or defacing a bond or an instrument was you punch a hole in it. That's why if you go look at any railroad trust deeds types of things from way back in the day when investors are getting certificates back from railroad companies, they got holes punched all over this thing in specific sequences and codes and all kinds of cool shit. I sent documents into land titles with Dean in the past, originals, and they got sent back clearly because we didn't have our process quite dialed with the left-hand corner of the document. And I'm talking a substantial chunk of the corner where the staple, no, sorry, it wasn't staples, it was the two rivets holding our live particulars of birth document together. They cut that off. And then they took black Sharpie and they blotted out the barcode at the bottom of the certificate. Things are going on in the background. If I don't have silver or gold to attach to a document or an item for consideration, would it be reasonable to attach soil, hair, or leaf, maybe clothing, wool as an alternative? Yeah, you know what? I think it's going to get a chuckle out of the judge for sure. All we technically have to attach here is love and consideration. Write that. That's all you have to say. I'm going to say 30, 40 years ago, it wasn't abolished, but they stopped entertaining the use of love and affection. Why? Because I'm going to suggest with that, as you're acting in person, you're not capable of love and affection. You're not. So they literally just stopped using it. When you go to a lawyer and have your land deals transferred, here's the funny thing. To be honest with you, folks, nothing's really transferring in the background. I'll explain that on another show. But so if to transfer land, you had to have a written signature, because the land transfers are probably the most valuable out there. There is none other than more valuable than a land transfer. Again, scripture talks about the land a lot. Creator's giving us the land. Your inheritance is in the land. Land, land, land. You notice how there's no water in there. Our inheritance is not in the water. That's for the Levites, technically. So yeah, if you wanted to attach something of value, whatever you deem to be valuable, and if the party in agreement also thinks that that's valuable, which you can just tell them, hey. But technically, no, they're looking for a coin. They're looking for a stamp, a special kind of stamp, like a stamp backed by silver. I know China's got some with gold fringe, actual gold leaf fringe on it, which makes them a little bit more valuable. I wouldn't say I'm super excited about using Chinese currency to back our private trust funds and equity on the Commonwealth side. I don't know if I'd go there, but you get the idea. A money order, you go get a money order and then get the serial number off the money order. Make the money order out for $21. There, that's another form of consideration. Okay, so back to the quickly the love and affection. You have to overcome the coming singular, though. Don't come as just the person if you plan on expressing love and affection. You got to come in your dual capacity. Make sure that's in your paperwork. Duly executed, duly signed, duly delivered, duly endorsed, duly delivered. All kinds of duality going on here. If that's not, throughout your documents, make it so. Turning in child's birth certificate with adverse claim question she has, and she is 11 years old. Does she sign it herself? Yeah, I would. Have the minor sign it. Again, we can act, the minors can act in a minor capacity. As long as there's a mom or dad acting in a major capacity, though, that's going to be important. And then throughout there somewhere, if the 11-year-old could have a written statement, this is a minor statement, Your Honor. Maybe it doesn't have all the equitable weight that a statement of a majority individual would have, but you know what? Again, the judge is going to love the application of it. The judge is going to love you trying, and it's going to get that 11-year-old elevated. Can you imagine an 11-year-old who's on first name basis with the chief judge of your state or province? Like, where there's a relationship of trust, and the 11-year-old actually kind of knows what the grantee, grantor, beneficiary stuff means, and it can actually have a bit of a conversation with the judge, and the 11-year-old could literally appropriate trust funds if the judge thinks it's in an appropriate manner. Yeah, why would we stop an 11-year-old from trying to express their will? Because they're not of the age of majority, says who? The legal world? No, I'm suggesting we can blow right around that. So yeah, get her to sign it, I'm thinking, for sure. Does one need to file the case of adverse title at the public courthouse, or can it be brought into a current case in the legal system? Yeah, you can bring it into a current case, but you got to do it through a cross claim, a counterclaim. Don't just insert it into the file that you've already got going. Nope, they'll defeat it. They won't want to see it. They won't want to touch it. That's going to open a whole can of worms that they do not want to deal with on the public side, so they'll ignore it. Bring it in on the counterclaim side, though, absolutely. Jody or Darren, a Dean, or any other person who has surrendered the birth certificate. Yeah, we're all in the process of doing that. I'm going to order another one here right away and direct it to do a something right out of the gate, because I ordered one 6 months ago. I filled it out properly, like I was advertising. I had that certificate sent to the Registrar General of Canada on my trust's behalf, technically. And you know what? He sent it back to me. Clifford's heir. Sorry, Clifford's hire. Hierarchy. Mentioned that the other day. So now I roll into the post office. How do I get my registered mail with Clifford's hire? Do you got photo ID for that? No. Fuck, dropped the ball there. So I had to send it back to the Registrar General and ask them, okay, can you please send it special delivery, but under normal circumstances, just not registered, and or hand deliver it. But anyway, I'm still waiting for that one, so I don't want to wait for that because I'm spinning my tires. I want to be more productive, so I'm ordering up another one and directed appropriately. When a statement of claim is filed, is that not a security for the court? If you attach security to it, what form of security? Whose security interest? When we technically abandon all that stuff, otherwise, that's where they swoop it in and take it. But is there a security in the courtroom? You betcha there is. You, the man or woman, and the certificate, the person, is also in the courthouse. And then they create all these derivative securities, all these other bonds after the fact. So this is what gives them the ability to negotiate these things: agreement and acceptance, offer and consent, all these things. This is what's getting these economic commercial wheels spinning in the background that we all see every day. We think this is normal and this is how it should be. Well, this is a result of us using imperfect titles without proper permission and with no trust in place. This is the result, and it's not good. We might look around and say, well, it's not that bad, Darren. All I'm suggesting is that it could be a lot freaking better, but it can't be better until we correct our problem here. And wouldn't the statement of claim have been granted for the benefit of the man, for example? Yeah, that grant is sitting on the table. Do you take it for granted? Nope. And as soon as you don't, you left it. You abandoned it. Again, this is where I'm suggesting the adverse claim and coming from adverse possession, right? Because we took possession of certain property in an adverse manner. It wasn't the true way of doing it. We identified as it, then we created this whole problem. Debt. We created debt, not just for me. I created debt for you. This is why we're all equally responsible for public debt. My screw ups are, just as bad as yours. Ryan Matthew, and as a result, security was granted. So yeah, the security is sitting there. Also for the court, yeah. Okay, so again, this is where we just you accept something. I accept as grantee, and in the same or alternate motion, Your Honor, I'm coming now as the grantor because I got the thing. I can prove it. I just set it onto the record. There, it's there. And now I wish to dispose or grant. What? Well, you better know what you want to grant and to who. As soon as you're 3/4 of the way there. As soon as you can just get that basic information out. But what's this for? Well, the enforcement of a trust, Your Honor. So you see how you're answering his questions with more evidence that just keeps slamming nails in the coffins? As soon as you get caught there with your pants down feeling and you don't kind of come up with an articulated answer that's for your benefit, you missed an opportunity. And this is the whole premise of our classes here, is to arm you in a peaceful way with as much knowledge as I can, so that you can roll into these situations and express trust on the fly. Because are they effective when you just speak them? Absolutely. But you got to know how to follow it all the way through, though. And since I'm not a trustee, okay, you're not a trustee. If you showed up in court with the person, endorsed it properly, hey, I'm no longer a trustee. I can't be, because I just, by an absolute assignment here, Your Honor, disposed of the legal interest as it relates to this particular case anyway. Whatever that is, and I'm assigning it, and I'm duly appointing it to the gentleman or woman standing here to my right, who's already identified themselves as such and such. And whether I take their oath on bond or not, Your Honor, that's going to be another matter. Maybe I'll just let them off the hook if they want to reimburse the trust for any trespasses. You start talking like this, the judge is already coming unglued. He already has to seal the courtroom because you've already said too much. But again, do this in a loving manner. Don't get caught up with the whipping stones at the judge, because he's our friend. The thing called the lawyers attacking it on a legal basis. Yeah, correct. But if there's no equitable interests, if there's no equitable interest present, then that's all the lawyer has to work with. So he's technically doing his job. Can she not be appointed as trustee even if there is an affidavit showing the appointment via registered mail? Yeah. If you've got some evidence saying that this has already been done, Your Honor, look, just make sure that's in your affidavit that you put in your counterclaim. Again, counterclaim removes you from the defendant position, puts you in the petitioner's position. Now you can lay some smack down. You're petitioning with doctrine, Your Honor, and under the doctrine of merger, and under the doctrine of clean hands, and under the doctrine of this, and under the doctrine of that. You can lay out some pretty serious smack, to the point where the judges left no choice but to convert the proceedings into a private chambers matter, because this is not in the public interest that this all gets out. In that particular matter, yeah. And if so, and the lawyer continues to trespass on the claim, can something be done? Are we missing something? Yeah, again, the lawyer will stop trespassing on your claim as soon as you bring another claim. If you try to bring your claim within his, he has the power. He has you under this. You got no wiggle room. And a court won't presume you will have any interest in filing a counterclaim. Otherwise, you would have. So the judge is at liberty to, at his discretion, kick you in the ass. Should husband and wife bring a petition, birth certificate, affidavit together as one package? If you develop a trust and you're both beneficiaries or settlers of it, absolutely. To the same judge, your thoughts? There you go. I've read that the trust account can be claimed by yourself up until the age of 25. after which a proxy must be used, because once you hit 25, they file the abandonment papers, they probate the account again, and you cannot reclaim that account yourself, and a proxy is required. Is this true? Let's assume that is true. What would happen if you appointed the Attorney General as the proxy to the trust you just created? Which is kind of what we're doing anyway. See? Is this true? I'm going to say, yeah. I'm going to say, even if it's not true, let's pretend it is true, because that's going to force our hand, right? So this is where we use a shitty situation and we push through it. We actually develop a better, I don't want to call it an attack, but we develop a better offense by getting rid of the defense. What steps will be required of them to claim their minor account? As soon as you convert them, as soon as you say, hey, securities intermediaries, this is for a particular individual with some private, a whole bunch of good stuff over here. This particular securities account is associated or as relates to the master account. They will just kind of sit back and go, do they know what to do or say? And if we don't come forward with the stuff, they just kind of let it slide by. Because how are you going to hold them accountable? You can't, because if you knew the stuff, you would have already used it. So they're just like, oh, so close. And again, they can't get caught providing us with legal advice. And here's why. They're all deemed insiders. You've all heard of insider trading, right? So what happens when insiders get busted for securities fraud because this particular lawyer shares with his or her husband some secrets from the inside? And the husband goes now and creates a trust and does all this shit. And that's not fair. How do you know this, Darren? Well, because in these declarations of beneficial interest documents that I'm looking at through the banks, you want to know how many disclaimers they have that says, okay, if this is the settlor of the trust, does this particular settlor have any direct family members that are considered insiders? Do they have any other family members that are considered insiders? See, they're going to track them down. Where did you get your information from? You don't just show up out of the woodwork and have all these answers and nail this. No. If you do, they know there's an element of insider trading going on, and they want to know how you got how did you come into this information, Stephen? Did you write this? No, my wife, who's a lawyer, just gave it all to me, and I just really hope that I can access all this cool stuff Darren keeps talking about. You want to know what the judge says? Bing, not allowed. I came across this from CW, but don't know if this is the applicable for us here in Canada or would hinder the direction process we are working with. He speaks of acting as trustee for some parts and grantor for others. Is this usable info? Yeah, absolutely. Why? Because you're already deemed to be the trustee. That's a position we cannot get out of. We put ourselves there. Let's work with that. We're already the trustee. But again, the trustee, debtor / surety, a surety can stipulate. A surety can change the game if the surety knows how. A surety can force the creditors and the principal debtors to act on something. And if they don't within 30 days, that surety is exonerated from any liability as it relates to this particular trust expression. Give them 30 days. Gibson's book talks about this, exoneration of suretyship. It's pretty cool. So yeah, okay, so once you're a trustee, now you can come forward as grantor again, but trustee, be the grantee first, perfect your interest, have the whole thing. Once you've got the whole thing, take whatever you wish to grant away and get rid of it. Tic-tac-toe. It says it's such a simple ABC 1, 2, 3. But you see how if you miss one piece, it kind of doesn't work, which is why I can't remember how many times Dean and I were in court and doing all the shit we do. And you can see the judge is like, well, yeah, he had this whole demeanor about, well, you guys are close, but technically, as a rule of law, I can't let you through yet. You know, we've dealt with that for 20 whatever odd years now. Presenter, can you explain the 3 places we signed for and accepted for value? Yeah, you know what? If you want to sign, if you want to endorse the birth certificate on this side of it and on this side of it, and then the adverse claim that thing's attached to, there's 3 signatures right there. Another signature or endorsement, special endorsement on the affidavit, the supplemental affidavit that supports the adverse claim. Well, there's another one. Your petition, there's another one. Schedule, yeah, lots of times you got to sign a schedule. Okay, what am I at now? 6? So there's a lot of opportunity here for be dropping endorsements on all kinds of stuff. And again, the accepted for value. This is the trustee conversion on the grantee. That's where you want to be dropping the acceptances right there. Hey, Your Honor, I accepted this certificate as grantee. It was put into my possession, and by the very nature that was in my possession, kind of implies to the court that you're presumed to be the grantee. So it's kind of already presumed, but if you blow over it, you never refer to it, the judge or the court presumes you don't know it. And how can you use it as a defense if you don't know it? See, it's only our lack of wisdom. It's only our lack of knowledge that hurts us. Scripture's right on the money when it comes to this stuff. I'm reading on notaries and find that our notary is a magistrate. Yeah, they do have a lot of power. Can we use a notary to do an interlocutory order, a vesting order, and an accounting order? Then go to small claims court to get the declaratory judgment from the court to declare it all rather? Yeah, absolutely. Take your entire process, get it notarized. But again, try to put some flavor, try to put some private flavor on the notary's capacity. Well, what do you mean, Darren? When Dean and I do stuff, we have the notary is signing or endorsing on behalf of the Dominion of Canada. Before Canada, it was actually called Dominion, the Dominion. That's where all the equities were hiding. It was like the archaic, not quite archaic, but the old system is what land titles calls it. So don't be afraid of tapping onto the old system, because that's way before the public shit show took over in 33. But yeah, this process, absolutely. Have all your elements done, filed, have them attested to, witnessed, private witness. Now get a notary in his private capacity to smash their seal onto it. Now take all this stuff to a registrar at the courthouse. You want the courthouse seal on it, though, because the post office seal, I'm going to suggest that might be fruitful at the end of the day, but that's an entire process that I'm not completely familiar with, other than, hey, look at my postal process. What do you think, Your Honor? Boom. Let them endorse it. Let them put their fiat on it. Once the court agrees, you're good to go. Shall we be filling out the tax forms to indicate disposition when we surrender? Yeah, you know what? There's a lot of spots in the tax documents where we can start dropping this information in. But I'm going to suggest, rather than do the trustee job, unless you're proficient in this and experiment, and you know what? Feel free. This is how we get there. Again, you can never get in trouble, loved ones. Never. You can't get fined. You can't go to jail. You can't be threatened when all you're trying to do is create a trust. Hey, tax people, it's my intent to create a trust. Thereby, I'm declaring a trust as relates to this thing. The thing doesn't exist until you declare it on the public side. The thing doesn't exist until you proclaim it on the equity side. Come with two. Come with both. Come with a declaration and a proclamation. Here, I declared it in person, right? Because that's kind of how they want it. And here's my proclamation, the man or woman. And I know Dean and I, we kind of bounce on people now about, oh, you don't need to come into court with, I'm a man, I'm a woman. You know what? It's kind of implied. All they're really technically, like, they know there's a man here, but what they're interested in is who's the liable party. They know there's a man in court. They can see it. But you've got this legal person wrapped around your body. And so you can't really, he knows there's a presence in the courtroom, put it that way. There's an entity in the courtroom. So unless you know how to unzip your person, fold it up, or give it to the attorney standing there and zip him into it, perfect. That will get the job done. But anytime you have the ability to fill out tax forms, again, do your best. You're not going to get in trouble, because here's why. You're also sending the attorney general, hey, I'm doing this. And if this is no good, you might want to have the Minister of Finance get involved, because I'm appointing him a trustee of this thing too. And under your jurisdictional command, you guys are here to protect the trust. This is why duly appointing them administrators of your trust instantly puts them in a position where they have to protect it, not you. If someone sues the trust, the AG gets involved. The Minister of Finance is involved, not you, because you're the beneficiary enjoying quiet possession and use of the trust on a beach somewhere. You don't go to court. This is why Her Majesty the Queen, as in Elizabeth herself, can never technically be brought into a court. She has other representatives that do that for her, because she's private. If you want to try to bring the Queen, who's in her private capacity, into a public court, you're on crack. It's never going to happen. Stop trying. It doesn't work like that. Recognize what her system has laid down. Get on the private side. Join them on the righteous side. Yeah, I know there's a lot of crazy shit going on in the internet world right now, and all kinds of, we're going to see, this is going to be interesting how this all plays out in the very near future. But I'm just suggesting, let's pretend that the queen title position is neutral. Well, they're neutral because they have the ability to be private. And they know how to administer their own affairs. Do we list the director and administrator, and can they also be trustee? Yes, this is what I was just talking about. Duly appoint, though. You can't just appoint from the person. No, the attorney general will smash you. That's like the janitor saying, hey, CEO, shut up, janitor. Doesn't work like that. But when you come in your dual capacity, now here's how we affect the dual capacity. Come in ex rel. EX space REL. Put a little italic on it, put a little twist on it because it's Latin. Ex rel means ex relation, as in you're related to that thing. You're not the thing. I have a relationship with it, but I'm not it. That's why we go to jail. We show up as it. We never express the relations to it, because all the record shows is our relationship as it stands is we volunteer to be the liable party, and then we kind of just disappear. Aha, look, Your Honor, cop drives you in. I found the liable party. Charged, guilty. I found him in violation of such and such an offense. They create the bonds, the paperwork, the money, because you showed up in person. You had to, because they didn't fix the problem. The problem was, yeah, I'm not the person, though. Well, you're in possession of it, really, because here's an absolute assignment that would argue otherwise. Here, where I've duly appointed this attorney general or deputy attorney general or minister of finance or a clerk, any court officer can temporarily act as an appointed trustee to deal with stuff, but don't do it to the judge. Because now we have a conflict of interest where you're trying to get a man to empower your trust, but you just appointed him trustee, which is the shit position. So now how does the shit position give you the power to see? It doesn't work. Don't appoint the judge trustee. Director, you know what? Director is let's be careful with director, because this is something we want to be doing. When we're in direct control, when we have direct holdings, this means I can give directions. So I would rather, let's take director out of that. Let's just use executor and administrator then. Okay, don't use director. Trust me on this one. Would present agreement supersede past contracts? Absolutely. The past contracts were built in fraud. Again, the entire legal system is a construct. It is a result of fraud. If none of us participated in fraud, guess what would happen to the legal system? It would disappear. I shit you not. It will. We don't need corporations to conduct business with one another. If I want to go hire my neighbor to come use my lawnmower to cut my grass, I don't need, a whole other crazy element involved. I don't have to quote acts and statutes to have a binding agreement. No, the present contract, the present trust agreement trumps the contracts, because we're actually coming in with value. We're coming in with intent. We're coming in with equity. We're coming in with knowledge and wisdom. We're coming with peace, clean hands, and list the other 20 maxims if you want. See? This sets aside those old dirty, shitty contracts. This is why it's so important that we do this, because otherwise, those dirty, shitty contracts are a cloud on your life. And if you ever want to see the sunshine, I suggest you follow suit here. Is it best to do an irrevocable or revocable trust? Well, this depends on what you're trying to trust. If you want to have a trust that you can change on the fly, that's a revocable one. If you want to have a trust appointment between you and the Attorney General's office, you want that one to be irrevocable, because you never want that relationship to get screwed up somehow. You don't even have the power to undo it later. You don't. You might be able to bring it before a judge and have him reform it or amend it, or yeah, that could be a possibility. But no, you strip yourself of the ability to change it as soon as you make it irrevocable. And with that, once the trust is complete, is the settlor no longer the settlor? Settlor and then seen as the grantor. Hang on. The settlor no longer the settlor. Yeah, essentially, once the trust is settled, it's settled. The settlor capacity comes off. The settlor hat, go hang it up in the closet again. You don't need it. Now you go put the beneficiary hat back. Yeah, the beneficiary also has power to deal with problems, but you know what? The beneficiary is busy with its ass in the sand. Don't bug the beneficiary. Show up as the settlor. And you know what? Hey, Attorney General's office, I got a problem. Deal with it. Boom. You've granted them the power to act on behalf of the trust to protect it. This is them wielding a big ass sword. Let them have it. You got better things to do. So do we need trust to deal with different things? Yeah, technically there's no limit on the trust we can create. You can literally go create a specific trust for every specific thing that you can come up with in your life if you really wanted to. If you're one of these little, those little label makers, if you're a label maker freak and you love putting labels all over everything and numbers with intent and purpose and what file that's a part of, go ahead. No one's gonna, say that you're not organized. Okay, with different things like banks, health system, driving extra. Okay, so I kind of messed that one up. You know what? Again, no, you can literally create the one master trust. If you want to call it your last name trust, Clifford Trust. Within Clifford Trust, I have res. The res is identified as banks, health, system, driving, everything. And as long as you just write those things down. Driver's license number, 1, 2, 3, 4, 5, 12. Health card number, 17, 21, 63, whatever. Any of these little identifiers, yeah, just identify them. If you want to just go scan them, make a photocopy of them, and then make that part of your package. Sure, all you're doing there is helping out the trustees, because the trustees are going to go look at your medical cards, they're going to look at your social insurance number, all these things, and then there's we've done what we need to do. Here's all your cards back. Did something switch in the background? Yeah, absolutely. As a matter of fact, they might keep a lot of these things and issue new ones, because remember, the old one isn't quite old anymore now that it's been converted. It might need a reissue to bring the system up currently. Don't be surprised if that happens. When we change hats from the settlor to beneficiary for a moment, do we need to express those in the trust? You know what? You could. You could literally nail it down to time and place. At this time and place, I'm acting as grantee. 5 minutes later, I'm acting as settlor. 5 minutes after that, I'm now acting as beneficiary and not to be disturbed. Yeah, if you want. I don't think it's a bad idea. Is your interest perfected? Is there a moment in time when your interests are not perfected, where you're not gaining ground or traction? No, you're always protected. So don't get too hung up on it. The interests are always good. Do you have to have a paper trail of exchanging trust between the trustee to settlor back to the new trustee? Yeah, you know what? When you put that endorsement right on the face of the birth certificate, that is trust res right there. That's why I'm suggesting this is one of the most profound things we could be doing. You could technically just come up with an affidavit on the fly now to support this thing. If you kind of could muster 3 sentences to describe what this is for, you wouldn't even technically have to write it. So the paper trail, though, it does bounce back and forth. And I'm going to suggest, yeah, go ahead and document as much of this as we can, especially in the affidavit. On such and such a date, when I was acting as trustee, coming as the grantee, holding a perfected interest in such and such a certificated security and registered form, number, issue date, whereas 10 minutes later, I'm now acting as the settlor, and my intent is to grant a security interest to new trustees who I happen to have duly elected, nominated, and appointed. Right here, this individual. And as such, now 10 minutes after that, a curing period, if you want to call it. Now, I'll be sitting as the beneficiary now until the court sees fit to disturb me. And I shit you not, that's actually a term. I'm enjoying quiet possession and I'm not to be disturbed. That kind of sounds goofy, but it's seriously like Superman stuff. So the caps fiction get put into the trustee in a new trust and put the creator name as the beneficiary. Yeah, lots of times the settlor and beneficiary, it's in like bank documents, for example, where the settlor grantor and the beneficiary are the same individual. Yeah, that's a certain type of trust. That's a grantor trust. So we can actually identify and label some of these things as we go through here. Yeah, you can absolutely put the trustee's name on there if you want. But you know what? When you like, here's the example. Whoever signature is on your birth certificate, whether it's some minister from Treasury of some type, right? It'll be the Deputy Minister of Finance or something of this nature. That is the executor administrator position already sitting there in limbo, waiting for your endorsement and your title to show up. Once the beneficiary, settlor, and trustee are all present on the same instrument, guess what you got? You got a trust expression, and a freaking good one. Something that can't be undone. What man or woman is going to force your hand to come down and undo what you just intended to do? See how it can't be done? All a judge can do now is take what you tried to do and reform it if he or she deems it necessary. And here's why. In the legislation, it actually says, if the certificate of security is filled out incorrectly, we'll still take it. If the securitized collateral is created fraudulently, we can still take it, as long as the intent was in keeping with the terms of the agreement. Well, Darren, that doesn't make sense. But you know what? Think about it like this for a second. If you're coming from the trustee, the grantee, and the legal position, that's the fraud position, is it not? That's deemed to be the lunatic world. That's the fraud. So we can actually acknowledge, hey, yeah, we're already in the fraud suit. So I'm endorsing this thing technically in fraud. I'm not supposed to be acting as this thing. That's technically the breach. That's technically the fraud. So does it actually fall into the requirements of, even if it's being done in fraud, we'll still take it? And again, I'll post those two sections. I got to go dig them out of the Personal Property Security Act or wherever it is I got them. I'll post them on the Telegram chat. So yeah, I think I got that one. Therefore, we create the documentation sequence submitted in the role as appropriate to follow the process to get our desired end result. Yeah, absolutely. The more manifested intent you can roll in to your paperwork, the easier it's going to be for the judge. And again, loved ones, we're getting good at whittling this down. However, I know I posted the other day a chunk of the deed I'm working on. Again, that is the most hardcore technical sounding shit or written text that you will ever see from me. And trust me when I say a lot of it is grabbed out of existing deeds and trust expressions. It's a lot of that's not even my wording, but I understand the significance and the importance of what they're talking about here. So rather than me try to reformulate it in Darren words, let's just give it to the bank in bank words so that they know exactly what's going on. From that concentrated level of I soften it, and it just gets more digestible and palatable from there. When we go to court, who's going there? The person? Yep. The man or both? What should we not do? I'm going to suggest don't go to court. I'm going to suggest have your written agreement sent to the Attorney General ASAP. I'm going to post a variation of this here. Again, this was the security agreement and the administrative agreement working together. I don't think I ever did post the administrative agreement. This is the written agreement that the Attorney General is looking for. I can't act until you release me from certain duties and then empower me to do certain other ones. See how this works? That's affected through an agreement. If there's anything they don't like in your agreement, they'll put a red line through it or they'll call you. Or, hey, Samantha, your line 6A, where you say this, the AG's office would like to amend it to read the following. What do you think? Yeah, okay, I don't mind that. Whatever. This is why having a little bit of knowledge of what we're doing is going to come important. Otherwise, I don't foresee everyone, may I please direct your call to Darren? Please hold. Right? It's not going to work. This is why I want you all to have the foundational principles here. A man's going to go to court. The person's going to go to court, but neither of them are going to be you. This is what the Attorney General's job is for. Remember, once that trust is in place, this cup, you fill it with the right stuff. Now you pass the cup to them. They're now in custody of the cup. They're in possession of the cup. They've got instructions, they've got directions, they've got valuable consideration attached to securities, attached to security interests. Trust me, loved ones, there's a lot of wood, a lot of concrete sitting there. There's a lot of stuff, enough for them to act on. So if you have a court case tomorrow, email me or contact the Queens and say, yeah, okay, Darren, I got an emergency tomorrow. Okay, but other than that, I'm going to, in the next handful of days, start posting what this administrative agreement looks like. And all it is a proof. Hey, I have this on such and such a date. I did this with it. I did that with it. And then I did this with it. And then I did that with it. And now you're in possession of the whole thing. There. With the intent to create a trust. Do you accept the appointment or not? And here's the awesome part, loved ones. He can't disclaim. Here, so let me tweak that. Do you accept or disclaim the trust? He can't disclaim, because as soon as he disclaims, he admits the trust exists. In order to disclaim this thing, he had to acknowledge that this thing is here. Boom, you got him. Again, that's that loaded question, or that loaded statement. I love that one. When does a trip to land titles take place, and what do we do there? Again, you can affect a lot of this stuff yourself online. There's a lot of things we can do with financing statements. There's a lot of things we can do with, indicating who the successor in interest is. There's a lot of things we can do with securities at land titles, but I'm going to start just directing everybody. Let's just do the big push at this point to put everything we need to into the proper trustees' hands and let them go worry about it. Because I know you all are losing sleep. Oh, how do I get this fucking process done? Darren's not coming across with the information fast enough for me. You're probably out there. I hear you. I know that. Thing is, I'm trying to balance all this for everybody, but point is, get the AG working in his proper capacity as an indentured trustee. An indentured trustee is important, and it's got nothing to do with, well, I guess it kind of does. I was about to say with teeth, indenture, dentures, teeth. Well, you know what? In a loving, peaceful manner, our paperwork has a lot of bite. It actually does. An indentured trustee is a very specific type of trustee. They know what's going on. They are now presumed to be acting in good keeping or good faith, good reason, and good conscience. And for them to get out of wrongdoing, if you so allege it to be, they're going to have a tough time. So they're going to start treating you with a little bit more respect. So this is why I'm suggesting, loved ones, when we start firing this stuff out the door, be prepared for the phone to ring. Because a lot of times they're going to call you just to either verify that this is you, or verify, they're going to find something that they can ask you a question about, just to see if you kind of got your shit together. And at the worst case scenario, you can answer the phone like this: Equity will not aid a volunteer. How may we help you? This is the settlor speaking. Or you know what? No, I don't. This is the beneficiary speaking. Oh, well, I had a question regarding such and such credit card debt. Oh, well, I'm sorry. I'm going to have to forward you to the settlor, where he or she will get back to you. Probably in writing. Can I have your email address, please? Now you show up as the settlor. You got their question. What's the question I can forward to the settlor? Please email your question to the settlor. And again, they're going to have to actually title the document to the settlor of said trust number 12345. Make sure you convey that information, though, to whoever the agent is that's calling you. Oh, do you realize, Sally Sue, that you just made an inquiry respecting a private trust? And as such, I'm duty bound and duly authorized to now provide you certain notice that states the following. Take actual notice. Da, 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 da. There. And how we can actually pre-write this stuff out and then just have it sitting on standby by your phone. But don't be afraid when the phone rings. You will feel a position of, as soon as you take an original birth certificate, dress it up like I'm talking about, stick some consideration on it, wrap it in a trust indenture and a security agreement, and fire it at a bank. Watch what happens. They go into panic mode because they don't know what you're going to do. This is a big deal. Where am I here? Okay, and apparently we're taking a break in 2 minutes. To use the registered mail number as the trust case number, yep. How do we go about doing that? Again, this is where take the all caps, sending the man something. The envelope can be empty, believe it or not. All the information is on the outside of the envelope. All caps sending to you styled property. When you receive that envelope as grantee, you just accepted something from the all caps. What did you accept? 100% undivided legal interest in that birth certificate name. That's what was in the envelope. Now that you're in possession of that, you have it as grantee, accepted. That's pretty bona fide. That's a nice spot to be. That's evidence. That's proof that now you can come as the settlor grantor and actually dispose of an interest in that. How do you dispose of an interest in that if you don't have that? See, this is where Dean and I missed it 10 years ago. Yeah, and if you want, stick that RN number on everything. Everything, that, especially anything that you're going to drop your endorsement on, make sure that mail number's on there. The mail number, it's a federally protected, internationally protected thing that it has a whole bunch of power that we can start utilizing for ourselves. And again, this is all commerce stuff. With us another episode, we can get into that. Do we just handwrite it in at the post office? You can stick this thing on anything. On the little registered mail stickers, where the number is, put in trust, write in trust right after that number there. So whoever's receiving this thing instantly knows, oh, this is a trust expression. Boom. Okay, loved ones, we're just gonna keep trucking here. Again, a lot of the premise here is that we're just getting the information down. We can always go back and watch these things later, because I remember when I used to watch these things, every time I watched them, I learned more. Why is that? More wisdom and understanding, and all these things are finally materializing in our minds when you're sleeping, when you're meditating, when you're doing whatever it is you love to do. This whole thing's growing exponentially. Okay, where was I here? We were talking about the post office. So how to use the registered mail number as the trust case number. All you just got to do is identify it. For example, Canada, RN 186-805-735 Clifford Trust. You can name your trust anything. I'm just throwing mine out there. There, you've got a trust connected to a particular entity. Now these things are literally joined as soon as you declare it. And this is why these things are binding, because when you're expressing a trust, no other man or woman can come along and say, Darren, that's not what you intended to do. What? No, see, it doesn't happen. This is where our priority comes from. Okay, will you please give, sorry, again, here's the other thing. I got to read the entire question out so that the queens can develop the system curriculum a little better. So I'm going to read the whole question now, and then I'll go back and pick it apart. Okay, will you please give any wisdom that you have on the subject of bringing two matters to a judge at the same time? For exact example, a husband and wife sending two complete paperwork packages to the same judge in the same package. Yeah, you know what? If you, man and woman, husband, wife, enter into a marriage trust or a trust agreement for marriage purposes, we're developing some interesting paperwork already, and I just came up with that. So again, this is where, just sitting on the fly, and when the wheels spin, you can just create this stuff. So anyway, now you got this particularly titled document. That's a deed of trust because both parties are bringing consideration to it. We have a lot of proof on the table that we're already not acting in person. What does this agreement say? I don't know, put your vows in it for starters. How are you going to talk about property? Whose is what's is whose? In the event you die, what do I get? In the event that I die, what are you going to get? Define it a little bit. It doesn't have to be 100 pages long, but I suggest it's more than 2 sentences as well, so that this thing could be called upon as an exhibit for court purposes to prove or to enforce a trust. Again, this is why we want to be pretty diligent with our paperwork here. Now what would I do with my marriage certificate, Darren? The one you just described. Well, have the parties mail it to another entity. And then when that other entity receives it, it's pretty binding. Who's going to be the entity who receives it, Darren? I don't know. The registrar of deaths, births, and marriages? Have it notarized on the private side of the fence. Have a bunch of private witnesses to it. Again, you'll be surprised at what these deeds are capable of holding. or the intents and ideas that these expressions are capable of proliferating. We can get a lot of stuff done with these. So that's one way. Again, if you don't like the two packages, although you could do that as well with as a co-plaintiffs, or not plaintiffs, co-petitioners. Your Honor, the parties here to this agreement wish to be declared the beneficiaries of a marriage arrangement, Your Honor. And they both shall have titles evidencing such claim. That's to be recorded as a trust by a trustee, Your Honor. We don't know who that is, although you could maybe name the director of vital statistics or the deputy director, or anyone in vital stats. Pick someone with got some clout, though. Again, when we wrap these trusts around these people, they're stuck with them. The only way they can get out of it is to go to court and have a judge undo your trust expression when you do it properly. In the country where I am at, there are over 70 judges. I have spent hours sifting through all and want to make sure if I look for a civil judge only. You know what? The registrar who first opens this thing is going to know exactly where to send it based on what it says. So, yeah, I know I've mentioned in the past there is a pedigree of judges that you can actually go look up as kind of like their life story as a judge, and you can kind of see which cases they've presided over. I've never done this. I've heard this is possible. I've never invested a lot of time in this, but you know what? Send it to the chief judge. There. That's where you want to be going anyway, because ultimately she's going to be the one looking at this. So if you give it to the chief or the principal judge, not justice, or if you want to send it to the justice/chief judge, that's good too. But the judge technically is on the equity side. It's more the private side. Justices are acting more publicly. So again, just these little loose ends, these nuances that we can play with to help direct our paperwork. So yeah, don't worry. Don't get hung up on seeking and finding a judge that's really excellent for what you're trying to do. Because you know why? The Attorney General is going to do it for you anyway. He knows, their office knows what the best suited judge for this application is. They know. This is all handled internally at this point, loved ones. There's no technical public record that gets created after this. You literally get ghosted if you want, because all your life stuff is now in this trust. The trust has all your power sitting there, so that now someone else can see that power and be empowered by it to go do stuff for you. Remember, your servant is your money, not the shit in your back pocket. Wrong. Also, would a brand new judge be better than a very old seasoned judge? They're all going to want a chunk of this. We are such a unicorn. We are such an anomaly that comes forward doing this. We are like, imagine catching the biggest fish if you're into fishing. Imagine, the best Christmas morning, if that's what turns your crank. This is a very special event. And whoever this gets appointed to manage this, they're all excited, which is why they want us to be doing this. They want us to be coming forward and expressing this stuff in a reasonably framed manner so that they can come to our aid and assistance and help. Again, you got to give it to them in a method that they can understand it, that they can work with it. If we give it to them garbly goop, we can't really expect a whole lot back from garbly goop. This is why the intensity of these classes and this knowledge and wisdom, again, this is just to sharpen your ability to draw your own picture, or at least let me draw it, and then you actually can see it and interpret it and understand it. It's a good start, because at some point you will be past my level if you so choose to be. Again, I have an advantage because I've been doing this a long time. Someone that has just stumbled upon this 6 months ago, don't feel like you can never catch up, because you can, because you got me laying down an incredible way to learn it. I can sift out all the shit we don't technically need to know, saving a couple things. And with the help of others, we can actually expedite and streamline this to the point where it's quick. And it'll become so easy. This is why we have to protect it. We can't just give it to the idiots. And I'm referring to the idiots publicly. Don't take things personally, unless you like acting in person. Is a probate or bankruptcy judge required to access the account? Yeah, they're usually the more seasoned. They're usually the more knowledgeable when it comes to this. Again, don't worry, the AG and the chief judge of your state or province, they're going to know exactly where this needs to go. Again, I've mentioned the whole appointing the attorney general thing, and there's just a specific way you got to do it. There's a series of words. Ex-rel is one of them. Privately appointing the attorney general is another one. Knowing how to operate from there, again, you're just going to build the paperwork, and you got to give them enough substance that they can actually do their job. It's doable. So yeah, anyway, don't worry. The attorney general is going to send it exactly where they need to, because they are representing the trust. Okay, move it on. What do you write on the BC? Think of these things as checks. You have a private bank. The president of the bank has given you a check pre-authorized. So if you're in your mind, you're like, okay, well, I want to take this check that's half endorsed, or 50% of the parties showed up. Once I apply my 50%, we have a binding agreement. Now, as long as I make the agreement on this birth certificate, that's according to public law, I should be able to negotiate this thing just like a normal check. This is why they allow you to order quantity of birth certificates. Again, I don't know where it is in your neck of the woods, but for Manitoba, like where the province where this meat suit was born, I have the option of how many birth certificates do I want? Well, I've had 3 delivered that I can remember. Any more than 3? No. Yeah, I think 3. I've had 3 delivered at one time. Why would you ever need more than 1? Technically, right? Why? Unless we were meant to use these things commercially, but just don't identify as it. Don't say it's you, but I have a relationship to it. I'm empowered to pass it on to a pass-through trustee. There's another one. A securities intermediary like a bank. This note made payable to bearer, the bank, namely the bank, under section such and such and such and such, for the special and direct deposit in the some certain amount of, I don't know, put whatever the hell it is you're trying to do, or in the private acquisition of property, parcel identifier number, I don't know, stick an identifier number in there of some kind, all in relations to trust number, I don't know, maybe put your registered mail number there. See what you're spinning on here? You're basically creating a little possibility. You're just plugging in a whole bunch of voids or a whole bunch of left outs. Once you complete this thing and give it to the party you believe capable of handling and dealing with it from here, this thing is actually going to be capable of doing some pretty incredible stuff. Look at what it created when we identified as it. Look what happened. And that's using it shittily. Again, that's a word that exists. I'm sure it does. When we use it for properness, can you imagine that scope? Again, when everything starts lining up and that mechanism turns on, it's mind-blowing, loved ones, what's back there waiting for us. That's for dealing with a bank. What if you wanted to appoint it to the custody and care and control of the Attorney General in favor of the trust created in the residence of the province or state in which you live, where its principal trust residence is such and such under section 1234 of the Trustee Act? Or here's another one, loved ones. The Limitations Act is one we really need to be focused on, and here's why. Like I was saying in conjunction with Nick's video here the other day, latches start. Latches is, okay, you've taken too long to act on your shit. Now we're going to take it away from you. That technically they have that power until you do what you want to do. And all this is meant to do is to motivate you to get this done. Don't start this process and then just walk away and say, ah, shit, no, I don't want to do it no more. Because you just created a freaking something that someone's going to have to go deal with now, right? It's not fair. Point is, lashes come from a particular point in time. When did that particular point in time start? Well, according to my trust indenture and security agreement under the Limitations Act, section 15, this is when the clock starts. Now that you have that, you've actually brought the Limitations Act into your trust. I know that doesn't sound right, but for good reason though. Because now, because the clock is running, this is going to compel the new trustees to get on and do their job. Because if you suffer any loss or harm based on their negligence, wrongdoing, misfeasance of office. Now they can be held for breach, right? But the clock technically has to start somewhere, so start it under the Limitations Act. So again, touching on what do we write on the BC, all kinds of stuff, loved ones. It all depends on what the hell you want to do. I'm going to suggest you can probably take one to a bank and get a special account set up for set off, because now you've got real securities showing up with collateral, with an agreement, and the appointment of trustees, managers, receivers. This is a value. This is what they call a financial asset. The bank has never held a financial asset in your name before. You always assumed that thing's debt and responsibility, liability, by going out and working 9 to 5 to pay for this thing. Why? When we didn't have to. That was a shittily choice on our behalf. What wording is needed for the declaration and the proclamation to smash the two interests together, Your Honor? Notice the following. I, of sound mind and proper intent, on such and such a date, acting in this capacity and holding this interest. Trustee, grantee, holding 100% undivided legal title to certain entities here, certificate, where I'm without notice that there's any other prior, equal, or superior claim in at law or equity that an encumbrance, a lien, a mortgage, or something else exists against this certificate, except for the ones I'm about to put on it. I'm well aware of these ones. That's where you get your firsthand knowledge from, because you did it and you scribbled it here. And again, we can be a little bit technical with our wording here. They're going to be pretty graceful. They're going to be lenient here because, like I said earlier in tonight's program, they got two pretty beefy chunks of legislation that say, hey, as long as you give us something, we can work with it. Even if you fucking do it fraudulently, as long as the intent was clean, we can work with it. So again, don't think of the birth certificate. You got to get it exact. Yeah, do it good. Do a good job. Be precise. If you want to send me, or if you guys want to talk online about how can we make this better? Because you know what, loved ones, yes, the adverse claim specific that Divergence came up with a year ago was very specific to get our asses out of a particular something in case someone came knocking on your door and was trying to enforce it tomorrow, right? That's where the entire premise of that adverse claim and an immediate relief, that's all it was technically designed to do. We've morphed it and expanded upon it to accommodate other purposes. So here we are. But don't get all hung up about what's going on in that birth certificate. You can also, and please refer to page 1 on Schedule A1, marked and dated February 3rd, whatever. That schedule can also contain a whole bunch of shit. You can attach all kinds of stuff to a schedule. Schedules make up an important part of an affidavit and the court process. Speaking of court process and doing pretty slick things in terms of wording, again, I mentioned it the other day on Nick's continuance. Memorandum and prospectuses. Get familiar with that word, prospectuses, or a prospectus. I was kind of shocked when I started to read some of the stuff in tow with the meaning of this one. Something we definitely want to be using. And again, it's not necessarily a legal word. There's a lot of equity in it too. So again, if you want, I can post some of the things I found or I saw, but if you do a little Googling, you'll see them. It's pretty smashing. So that's how we smash these two interests together. You declare it. They only merge when both interests are present in the same person or same individual. When you got both, one of these has to go, because I can't stand before my father any longer being dual-minded, Your Honor. That would be unconscionable. That would be contrary to equity. That would be in bad faith. That would not be in good reason at all. And I know I'm being judged. Am I not, Your Honor? All the time. So clearly, we got to deal with this right now. And actually, that right there is enough to constitute an emergency hearing. Absolutely it is. This is a matter of faith stuff. This isn't, I stole a chocolate bar. No. That's not an emergency. That happens all the time. A man or a woman leaving that sea, coming back, and having the wherewithal to affect God's will, doing what we're supposed to do. Look out, people. This is why, again, loved ones in the States who've had students come out of courtrooms, and they've had the staff of the entire court building lined up in the hallway, saluting the gentleman as he walked out. Well, that guy did something right. And I'm thinking we're starting to do a lot of stuff right as soon as we dispossess ourselves of that certificated security interest. Darren, does that technically mean the certificate itself? I'm going to say, yeah, just do it for now. The system wants the originals. Darren, would a PDF scan version of an original sent to a bank fly? Yeah, they do. I'm suggesting, though, send the original. Let them have it. If they want to peel the coin off of it and do stuff to it and send it back, let them. Just let this system unfold how it's supposed to be doing. Again, we've had documents come back with coin, without coin, and then we've had no documents come back. So we've had all three. So there's really no surprises anymore at this point. But get them the equitable titles, get them the certificates, the real ones. So if you do want to scan a PDF version of it to somebody, go ahead and have your mail-in versions on standby so you can fire them right, like tickety-boo, like quick though, because you want them in possession of that thing as soon as you can. So Darren, does that mean, do you have to have gotten rid of the certificate indefinite, like right now though? No. You could actually say, in reference to certificate number 1234561, I hereby stipulate and in trust create the following relations. You, I'm identifying you are duly nominated, duly elected, and duly appointed thereby under the Trustee Act for a full-blown trusteeship. Congratulations! If you wish to get out of it, you may disclaim the trust at any convenient time in courthouse near you. Bring your lawnmower. If our hands are clean, is there a such thing as a really clean hands, as I saw posted? Yeah, here's the thing. Once we dispose ourselves of the filth and we've pawned it off, we've given the filth to the Attorney General's office for an undertaking. Why? And once they bury that corpse, why would you go in the middle of the night with shovels and flashlights and go dig that corpse up and start having intercourse with it again? Do not let Father catch you doing that. Do not. We gave it, we granted it, we disposed of it, we applied it to a particular party that we know is the one who's supposed to be dealing with this. Don't go steal it back again. I don't even want to describe the types of lightning bolts with your name on it heading en route. So yeah, the really clean hands technically happens the moment we do this stuff. So stay clean after that, because there's going to be penalties. If you get all cleaned up and then you intentionally go cause harm or go do something stupid when you know you shouldn't have, expect a lightning bolt. And I'm going to suggest a fucking good one. So think twice, or maybe even 3 times. But again, here's the cool thing. Look how clean we are already spiritually. And I'm just talking about the loved ones here. You know, there's a lot of people that are coming online now with a whole new attitude. We're tired of fighting. We don't want to fight no more. We just want peace. We want to get this problem solved that we now understand that we helped create. So again, this is the whole coming in honor thing. This is what clean hands technically means. It's not coming dirty. Your Honor, my intentions are clean. I made a discovery over here, and I know there's court rules for processes of discovery. Might want to include that in our petition. Sure, that's a gooder, because that's going to be an avenue, that's going to be the mode that we get our evidence into the court. A motion for discovery. Your Honor, I discovered the following. On such and such a date, I became aware of a trust. And now I'm obligated now to come forward and present my findings and give it to you so that I may be granted grace, mercy, and milk and honey. So again, the clean hands is an important concept here, loved ones. The court process in speaking with the judge is a big one for me, and as well, we submit each piece ID, birth certificate, i.e. the birth certificate coin, and then land titles office. How many things are we entering there, and how do we get that piece completed? Yeah, we're going to really want to be talking primarily about debtors and creditors. That's one of the primary things that land titles is looking for. They're looking for some type of an encumbrance or some type of paperwork that locks down this name and everything attached to it. Well, this is where they're going to give us the ability to actually put trust indentures around personal property, such as chattels. Chattels is another word for a certificate. So this process, we can tic-tac-toe a presentation to the registrar of deeds at land titles, where you can say, hey, under an appointment here, I have duly disposed of an interest in such and such, and whereby I intend to go to court to have the titles realized and enforced, acted upon, all kinds of good stuff, injunctions, accountings, get creative there if you want. Now, when the registrar at land titles sees this and that a certificate show up, they're like, ooh, yeah, okay, yep, we will give you a new certificate now. This is called the certificate of pending litigation, or a lis pendens. A lis pendens is something you now take to the judge and you say, hey, look what I got. And now the judge knows exactly what you got, because he can go on his little computer, punch in a few things, and he has direct access. He sees everything you just filed at land titles. And he's like, oh yeah, okay. I see all your substance. I see your trust expression. And because again, loved ones, the mechanism really, really, really engages when we show up at land titles and we get our shit recorded. That's a big part of this mechanism. Do you have to get that done there now before you send it to the AG? No. And here's why. Because there's going to be a new registered owner of this thing, the birth certificate, when we're done with it. The new registered owner is who? The successor in interest. The new trustees. They now are deemed the registered owner. They take all your stuff and mix it with a bunch of their stuff. Now they go to land titles and they register this stuff as the trustees and the new registered owners. And it's probably going to have a, on behalf of Her Majesty the Queen and right of the province or state of such and such, that's going to have a very proficient overtone. That's who the new liable party is going to be. That's who the new registered owner is. And who pays the bills now? Who's the registered owner? This thing sitting over here, all wrapped up in a trust. So again, I'm going to suggest pawn all this shit off on the AG's office unless you get tickled pink and love doing the trustee stuff. Yeah, again, because there's a lot of knowledge there. There's a lot of wisdom. I would not deter you directly from doing it. The more things we do and try, again, if your intent is clean, you don't get in trouble for this. This is why they give you the ability to order extra birth certificates. You never are going to get in trouble for trying to express a trust. It just cannot happen. Is there a conversation to be had about the evidence of success in equity without reflecting poorly on our faith or focus? It seems we are all of various stages of pursuing. Who has had successes and to what degree? Okay, I'm just going to spend a few minutes on this one. Fantastic friend of ours in the United States there, him and his crew, they caused Brexit to happen. Brexit was a result of the Lieber scandal. The Lieber scandal is mortgage fraud that was found in England, where the lawyers and bankers were generally found guilty of fraud, mortgage fraud, to the tune of, I want to say trillions, like lots, ridiculous amounts of money. This came out of the Second Circuit Court out of the United States. Okay, so now England is on the hook for a lot of dough. They just got found guilty of this whole Lieber scandal. This means the rest of the EU, the European Union, did not want to be a part of this debt. They're like, we need to separate. We need to put a new arrangement in place because your debt, by our prior agreements, means we're a party to your debt. No, that was your mortgage fuck up. That had nothing to do with us. You eat it. That's technically what caused Brexit, loved ones. Our friend in the States here, him and his friends caused it because of a court process that they had done with a mortgage product and the resulting fraud and how they undid the fraud. Yes, equity vitiates all fraud. So in doing that, they had to be notified of being a potential candidate now to be compensated from this Lieber scandal, this incredible fund due to mortgage fraud because they brought a proper mortgage claim on doing the fraud. Now they were entitled to this. This party, they got a letter from the 60, they got a letter from a law firm representing 16 of the world's largest banks. And this letter essentially says, yeah, we've been found guilty of this, and yeah, whatever you stake your claim in as please just send it to such and such address. So this guy, whoever this party was, they would have tapped another massive chunk of funding because of this fraudulent case going over here. But again, a member of the public cannot have access to this because they're social citizens with no rights. They can't access it. Again, what kind of big deals has equity been involved with? Well, there's a good one. The Panama Papers scandal. There's another one. A whole like trillions of virtually of investor money, offshore investing, right? That's where all the wealthy are throwing all their money. Panama, some bank in Panama. Something was alleged where money was going for bad purposes, or something happened and something bad happened, and then a big leak happened and a whole bunch of information was let out to the public, and it involved a whole bunch of scandals, right? They, as in the system, recovered all that money, put a hush gag order on the whole project. I was told that the United States sent in special forces team to Panama to take control, to make sure that that bank was dealt with properly, because there was private citizens' funds mixed into that particular bank account. So a judge sitting in chambers exercising his long-reaching arm of equity could literally reach all the way over to Panama through equity and have something dealt with to protect the private interests of trusts. Some of the other stuff, again, Dean and I just in the past, Dean's discharged big mortgages in the past. Dean has put an application to the land people saying that he wants a big chunk of Crown land. And the Crown people got back to him and said, well, yeah, okay, we'll do it, but can you just please pick something not in a provincial park? Dean took that and he thumbtacked it up on the cork board, never touched it again. There, they acknowledged it. They'll do land transfers based on your paperwork. And he sent in a money order when he did that. There's the valuable consideration. And I'll tell you, whatever wording he put on to get that pulled off, we're way better dialed and prepared nowadays. Can you just pick something not in a provincial park? So all he had to do was resubmit, identify a chunk of Crown land not in a provincial park, and he would have been awarded some type of usable grant. Again, discharging mortgages, getting ourselves out of jail, having mortgages foreclosure proceedings stopped, having your driver's abstract completely cleaned. You know, you get a notice in your mail says, hey, your drive abstract is blank. This is it. But you know for a fact, you got caught for speeding a number of times. Oh, you might have even had a drunk driving charge on there. What? Gone. There's another example of equity working. Tons and tons and tons and tons. I could probably do a show just on that, so I can't burn up a lot of time on this one for that. But trust me, the remedy, the relief, yeah, it's real. When Darren referenced that the et al. And others on his petition, is that how the family goes through? Yes. Or is it done individually? Yeah, let's piggyback others as you are going through, yeah, and your others. That's how this thing grows. How to enforce a trust expression. Yeah, that's how your opening clause to frame your motion or your petition before a judge. You're bringing your petition ex rel, that means in a different relation to the subject matter, which is this thing, the all caps, but we're actually going to send it to the Attorney General, and he's going to bring the claim in the name of the state against who? The state. You see how they can't have that? Keep in mind, loved ones, the Attorney General's office will bring a claim on behalf of the state or against the state. How can he bring a claim to himself? You see how this just instantly dissolves internally? We have to bring it. Yeah, so is this how the family goes through? Yeah, that's how you express the trust. Yeah. Again, you're going to be wanting to be using exclusive, equitable prayers for relief here when you're enforcing this trust expression. This is where I would be a little hesitant to say use the Trustee Act or the Limitations Act to try to enforce your trust. It might be tempting, but I'm just going to suggest we don't do that. We want to be bringing in doctrine, jurisprudence, and the maxims to enforce our trust. Equity imputes an intention to fulfill an obligation, Your Honor. Ta-da! There's a good one. I could probably rattle off 5 more, but again, continuing here. Who has succeeded in assessing or accessing, sorry, part or all of the said it. Hang on, this one's for Kim. Trust. Yeah, I've heard of a number of people that have done it.
She's better at it.
But the thing here is, I'm sure Once you pull this off, you're deemed an insider. And if an insider gets caught to the outside, see how you're going to, this is why these non-disclosure agreements get brought in, loved ones, you see? I'm thinking that's a very real deal, because why then, I'm going to suggest for the most part that a lot of these people that have gotten through, I'm hoping that they had the right intent. And I was hoping that they would have wanted to be helping others. I do know of this one lady who was a sheriff or a guard at a jail in Ontario, where she all of a sudden had the government pay for her and her entire family brand new cars, big gas, brand new houses, all the toys. And when Buddy at the jail was asking her about it, did it have anything to do with the birth certificate? She stopped stone cold and never talked to this guy again. Never mind, just not talking about the birth certificate. She literally stopped talking to him. Why? Because what if she's being watched and she's being listened to? I know I'm being listened to all the time. So if I continue to share insider information, I'm setting myself up for a burn. I would rather you all go through squeaky, quiet, clean. Again, what do you think enjoying quiet possession actually means? Does it say enjoying loud possession? No. Quiet means shh. Once you get it, it's probably going to be so simple. Keep it fucking quiet. Don't be making YouTube videos and doing big Zoom meetings about it. Do you think this could be declared in small claims? Okay. I think I answered this one in the chat on Telegram. I think I said yes, but you know what? To be honest with you, because this is considered a large estate or a large trust, this is actually out of the jurisdiction of small claims court. I'm going to suggest you can bring a bunch of evidences in through small claims, then get the process going, and then bring that information up to another petition in a court of competent jurisdiction. I would suggest you could do that, but to believe we're going to get full remedy at the small claims level, I'm going to say it doesn't really matter, because the Attorney General is going to do it all free in the background anyway. It's never going to be made public again. Once we do this stuff, it goes, it's out the room, down the hallway, running. We never see it again. And they do a really good job protecting it and its interests. They have to. So if a lawyer, notary is to notarize the docs and then take them to small claims for declaration, yeah, okay, there. You could probably get the claim declared there, yeah. But to appoint a receiver manager, to appoint new trustees, appoint commissioners, things of this nature, that's going to require a judge with a little bit more jam under his belt. So you're going to have to go up. Can we declare ourselves as woe-men to be creditors and issue bonds through the person and then treasury? Yeah, that's essentially what's happening here. We put that thing into the possession of another party with the intent to sell it. So we define in our agreement here, okay, what portion to what amount and for how long. We just got to define a few of these variables. And once we do this, they can act on it. But yeah, that bond, that we bond. Okay, so the bond of the person was put around our necks, right? It was our life that brought value to this equation. So now we've taken that thing off and we've gone and given it to a new trustee, plus the certificate itself. They go and do a whole bunch of cool stuff in the background. And again, if you really want to know that trustee stuff, once you're on that side of the fence, I'm sure you can make inquiries. You can actually probably go ask the Attorney General or the Minister of Finance for a private disclosure. I want to know what's going on here. They're going to have to give it to you. They'll literally have to tell you exactly what it is. And if they don't, you just motion it to a judge. Your Honor, because this has bearing, or because the trust has an interest in this process, a representative of the trust is duly inquiring as to the following 1, 2, 3, 4, 5 questions. Thank you. Yeah, they'll have to answer it, but again, privately. And then don't take that shit on into the public and start making YouTube videos about it. No, again, this is where coming with clean hands actually means that we're trying to act with some honor and some dignity and respect and all these good, loving things that Scripture is trying to tell us to do. Does anyone else supply public service corporations with their own fee schedule? Again, you know what? This is all going to be wrapped up when the AG takes over. When that little switch gets thrown for you in your name, you get reclassified. You actually become classified. You go from public classification to reclassification private, and now you're actually classified, like the real one, as in the military. No, this is classified, top secret. No one else has access to this. The only way someone can get access to it is through the Attorney General's office, and they would have to prove their privity to your trust. And they would have to show the Attorney General that, well, I got a signed document by Darren here. He suggested that on such and such a date I was to become a beneficiary if I had gone through the wisdom system and I proved myself proficient. So here, I'm here to collect on my reward. Yeah, who knows? Can you imagine if a trust like that was being built in the background and you had no fucking idea? Which is why it was important that I actually knew what your names were. I don't know. Just throwing shit out there. Is the BC an estate title to a trust of land? Yep. And is it treated as a mortgage? Yeah, that was we did that one right at the beginning. When the security agreement is perfected and we no longer possess it, and the new trustee appointed, does the original Seteke trust fold in all the bonds under the all caps name and the remainder transfer to new private settlor created trust? Or is there a new Seteke V trust in addition to the newly sprung private trust? Okay, let's just go right back to the beginning here. When the security agreement is perfected and we no longer possess it and the new trustee appointed, does the original trust fold in all the bonds? Yeah, every commercial note, every commercial activity, every commercial transaction is now called and brought forward and dropped into your trust. So this is why there's an army of these accountant types and clerks and buildings and buildings and buildings full of these government people. Well, doing what? Well, they're on standby waiting for us to show up. We have entire floors dedicated to servicing us. And I don't really like calling us a creditor. Maybe like an intermediate creditor or an intermediary creditor. Again, I prefer just to call a creator the creditor. We're just like a facilitator in the middle. So, okay, yeah, the initial trust collapses. Yes, it's replaced by a permanent one. The temporary one just got junked. Permanent one now takes its place. It's all by your appointments, your doings, your expressions, consideration, all the things that we talk about. This is why this one has value. The other one had no value. There was no parties to that agreement. Can you imagine having an agreement with nobody? What do you got? So the remainder transferred to the new private settlor created trust. Yes, all the interests get moved over. Or is there still the old trust in addition to the newly sprung private trust? Yeah, no, I'm going to suggest that they probably dispose. When they cancel that certificate, they're probably going to dispose of and destroy certain stuff because all they really give a shit about is the current version, the updated version. This is what technically matters. They can probably dispose of a lot of paperwork over here. And I'm sure, we probably authorize them to do it somehow, some way. Again, your mortgage, you literally authorize them to destroy the original and replace it with a copy to serve slightly different new purposes. Whose purposes? Yeah, theirs. Nice little, right? Can you go over a flow chart of grantee, trustee to grantor, settlor to when to announce new beneficiaries in the relationship to fill paperwork process start to finish of newly spring private trust? Yeah, you know what? Again, thanks, Nick. My original security agreement cited Manitoba statutes and named Party B as Treasury, care of Registrar General of Manitoba Secured Party, Successor in Interest, Transferee. Yep. Does this second security agreement, that is to accompany the individual letters to appoint and discharge named Party B as Her Majesty the Queen and right of the province of Manitoba, care of the Attorney General of Manitoba as the secured party possessor or secure successor in interest, transferee, or do I keep this second security agreement worded the same as the original security agreement? You know what? If we need to amend or make little change orders, yeah, feel free. You can always just add and amend right to that document. And again, our schedule is going to allow for this. This is why we reserve the right to add and amend. Because, right, how would it be reasonable that we would have gotten this entire process perfect 3 years ago? No, this is all trial and error, stumble upon. I heard this, let's try that. A little bit of from above. Yeah, a whole lot of that, as a matter of fact. Yeah, of course, we're going to want to be able to add stuff, which is why I'm going to suggest always make your trusts revocable, except for that one particular one, transferring that big badass interest to the new trustees. Make that one irrevocable. Every other one, make it revocable. So you always have the ability to massage it, allowing for life. 10 minutes. Okay, hang on for a second. Named the Party B as Treasury. Yeah, Party B. We're going to be naming indentured trustees. and securities intermediaries. These are the big players. So securities intermediaries, technically, is going to be Vital Statistics. They're a bank. If you want to deal with your, let's call it your dominion, versus just sending a bank a bond, a perfected interest for $1 million. Say, here, bank, chartered bank, franchisee bank, set me up a special account for set off up into including $1 million. And when I blow through the $1 million, you can sell another chunk, sever another chunk of the trust, sell another chunk of the trust to pay for the next $1 million. You can set this up all day long, and it doesn't have to be $1 million. Just throwing a number out there. Care of the Registrar General, successor in interest, Minister of Finance is probably going to be who I named as the successor in interest. The Registrar General, he's going to be, he's kind of a receiver. He acts in that appointment like a receiver, like an inspector general type. He's got a general office. But I wanted to fine tune it more so to the Minister of Finance. And again, loved ones, we don't really got to sweat this shit no more because the Attorney General is going to deal with all this for us. So, but you can see the method in my madness here where I wanted us to get familiar with this stuff so that when the Minister of Finance office calls you and says, hey, I just got a letter from the Attorney General's office suggesting the above, is this to be true and correct? Well, are you going to be afraid to answer that one? No, you might have to verify it at some level. They might have to prove or authenticate this to some degree. You might get a, hey, do you mind coming on in for a private sit down type of a thing? Do you mind if we send a black Suburban with 3 people in it to escort you to the facility? Yeah, because again, you're an asset now. You're not deemed to be a public enemy, lunatic, belligerent, all that shit. You're an asset, or you hold an asset directly, which is just as freaking valuable, if not more valuable. They know that you can create these instruments all fucking day long to the benefit of everybody, society at large, the public interest. That's why you are protected, because you're capable of a lot of shit your neighbor's not, unless you're doing it with them. So yeah, I can, you know what? This is probably better place where I'll go over one more better description of this whole paragraph here, and just expand on this a little bit, just because I know we're getting a little bit crunched for time here. When the security agreement is perfected and we no longer possess it and the new trustee appointed, does the original... Oh, I think I did this one already too. Yeah, I did that one. Okay, can you go over the full chart? Yeah, I think, Nick, fantastic job on that again, by the way. Again, as I mentioned in the other video the other day, see how many layers there is to this? We can literally just run off with line 1, you know, a day's worth of explanation. The second stage, like, there's a lot here, folks. And again, this is why we're all at such an advantage now, because we've had a lot of people in the past do a lot of incredible diligent digging and who have provided a lot of the substance that I'm talking about here today. So again, thanks to everybody, you included. Okay, you know what? Okay, I guess looking at this question to fulfill the relationship requirements of the paperwork process, start to finish, of the newly private trust. So you know what? Yeah, I will expand on that one a little bit. There is some room there. I can add some stuff. But again, let me develop a dedicated 20-minute just to deal with that. Is the deed of trust for our private living trust that we create? Yep. Or is it for the constructive trust that gets created after the merger of titles and the new trustee vested? Guess what? All of that's happening. That's all happening in our trust expression. As a result of these two titles coming together, boom, under merger, a resulting trust had to happen to catch the equitable interest and to supply or furnish the legal interest and give it to a new party. Once the judge sees that result of that event, now he can construct the big, badass, awesome trust. That's the constructive trust. It literally takes the place of the little resulting trust. This is what the judges and the courts are for. They put all this together for us perfectly, so there's not a freaking deficiency anywhere. Again, I know a thing or two, but I'm going to suggest that, you know what, the judge might have something on me that I don't know of, and I would rather it be built in by a man or woman qualified in this department who's got the trust's best interests in mind. They have to, under the doctrine of good reason, good faith, and good conscience. Bingo. How does one go about putting the name on special deposit? I would say, hey, bank, take as granted this name on special deposit for the purposes of furnishing capital to a privately held trust by you for a term of 5 years, signed here by me, and you're in a good position. Hey, what do you think? Fire that off to the bank. That's how you put the name on special deposit, not your name, the state's name, and your name. So you see how you got 3 parties now on this instrument? You got the state, you got a director, they're technically the one party, and then you got the all caps name, that's a different entity. Okay, so there's 2, and then you show up, you're the 3rd. If you got 3 parties, you definitely got a beneficiary, a settlor, and a trustee. We have to stop? Okay. Again, we can be very flexible with how we put the name on it for special deposit. As long as it doesn't say general deposit, put special on there. The assignment is going to be important. An absolute assignment, if you want to word it as such. Even if you want to declare this certificate to be a mortgage in equity, you can literally do it right there instead of quoting acts and statutes. It's another good go-to. So again, there's going to be a few, depending on what you want to do with the birth certificate. We can do all kinds of things with it, all kinds of stuff. There's all kinds of securities intermediaries out there that will accept these things if you present it properly. Again, they've given us some gray area here to work with in terms of what do we put on there versus what they're going to accept. Just give them a letter, write out, well, it's my intent and purpose to create a trust and for the following purposes, these are the parties, this is the duration of the trust, and you'll just build it. Have it notarized if you like, get witnesses to it. You got to define who the beneficiaries, the settlors, and the trustees are, though. Make sure that's in there. You can't ghost those things. If you want this to go through effectively and with some, immediate satisfaction, give as much as we can, and don't, we don't have to be worried, oh, is my paperwork going to be fatal if I put this clause? Well, no. If you expressed all of this and then one tiny little thing over here, no, the judge is going to say, no, the spirit of the document was this. The document is not rendered fatal because of one little misuse of a word or two. Don't worry. If we have multiple birth certificates, are we to include and surrender all copies? Again, depends on what you want to do. If you want to send one to the Attorney General, if you want to send one to a judge, if you want to send one to a bank, have at her. There is no limit to the amount of trusts we can express. But when we express a trust, we want to back it up with some value. We want to back it up with some collateral. Okay, Darren, what's the collateral? The actual certificate with all that information on it is the collateral. That's the collateral. Now we attach value to the collateral. Again, if you imagine going into a bank and the bank says, well, what do you got for collateral? I'm going to say, well, fuck, I got a Lamborghini for collateral. Can I now just show the bank manager a picture of a Lamborghini? Say, here's my Lamborghini. I want to use this as collateral. He was under the presumption that I was talking about a $800,000 sports car. Like I actually had the real thing, not a picture of one. But unless you define it in your expressions properly, could I have gotten away with a picture of it if I specially endorsed it and said, yeah, this picture is worth $800,000? Told you, I happen to know stuff about equity. Yeah, you could probably get that pushed through. But again, come with clean hands, come with, some intent, honor, dignity, this good stuff. The collateral is the birth certificate. If you want to submit one certificate to the Attorney General, identifying the trust and getting him to start acting as the administrator, you can also include the other certificates and say, here, and cancel these other ones. However, I am also going to be, in exchange, reserving my right to equitably enjoy the beneficial interest in any particular property that the settlor so chooses to invest in the trust. That car, that boat, that helicopter, that chunk of land where we can plant good crops and feed the world, whatever. It just rolls out from there. Okay, this is a long one. Oh no, yeah. Maiden name is on BC. Did I get this right? Nope. Okay. Do we list them on our notice to the clerk individually with the social insurance number? Definitely not referring to the certified SL statement of live birth. Again, whatever process we're at, whatever we've accomplished and done to date, we can basically just wrap this up at this point and put it in a package and be sending it off to the Attorney General. If we want to send it to the Deputy Attorney General in care of the Attorney General, yeah, that's probably not a bad idea as well. Again, the deputies are the lifetime appointees. Is the actors that we see out on stage for 4 years or whatever their government term is, they're not the lifetime appointments unless you appoint them to be. See, again, this is where we actually have I don't want to call it a weapon, but we have a something, call it a truth saber. Once we start waving this thing around, we can affect a lot of incredible stuff. And I'm talking quickly. And again, remember, loved ones, they're waiting for us. And again, with Samuel's little recording there about what he just went through with the court, you could hear it in the judge's voice that she was trying just to get a little bit more from Samuel so that she can start affecting this stuff. And again, not knowing how to frame the petition, or if there's a deficiency in the petition where it just needed a little bit more clarity, a little more specificity, then Samuel would have been greatly served by that. So anyway, maiden name is on the BC. Do we use that on the paperwork, or is the married name okay? I'm going to say whatever you go by now, just say as it relates to this name on this certificate. This is the same individual. There was a change of name due to a marriage. Just make a statement. Again, when we're declaring things and we're proclaiming things, these are some of the things we want to be declaring. And when I was 19, I got married and my name changed. And right, that type of thing. Regarding the live birth event, a member of our group has the mother's ancestral number and not the father's number on the live birth registration and any pertinent documents. The father's number is not to be found anywhere. The mother's case number, the documents show 2 numbers, mother's record number and baby's record number, which are the only 2 numbers that link the corporation birth certificate. Does this mother's ancestral number play a key role, or is the registration of the live birth not that important? If you say no, we are curious why. We believe these 2 numbers from the registration of live birth are mandatory to create the birth certificate. Yeah, I'm going to agree. They need some type of writing that they can affix a number to, like a file number or an abstract number. They need something to start the game. They don't really care what it is, how it's came to be. Yeah, they have legislation and statutes that influence us as to how they would like it. However, go look at the royal family. When they post their notice of birth with their little placard out in the front of the castle, that's not deemed to be public notice. Yeah, it's posted for the immediate local people to know, but it's not posted in a newspaper. It's not posted in a classified section. There, you posted a public birth in a classified section. What class? The public class. You just classified your own daughter or son. Again, dubious things that the system has us do. But again, we come in and we undo it all. So yeah, the documents, again, you're expressing your interest in these documents. That's what's technically important here. Let's say all those other instruments got burnt and you only got this one left. You can still develop that whole evidentiary chain in your affidavit and in your declaration. When you speak to these things, you just lay it out. And then I lost my birth certificate and whatever. Then I got married. Then you just define it. You just got to describe it. You got to give the judge something so we can see it, so that he understands the story that's before him. So yeah, don't get too carried away with all that. Whatever documents you have in your possession is all you need to do to convey that interest to the new party. You can attach any interest to a particular public piece of ID and get the entire process done. Why? Because it's all linked to itself. Your medical card is linked to your driver's license, is linked to your birth certificate, is linked to your social insurance number. So see, because it's all interlinked, I'm going to suggest we can probably knock this out of the park with any of it, as long as you develop your paperwork as such. What?
Okay, loved ones, we are at our 2-hour mark just because of the things that we have going on in the background, and for easier purposes of Kim converting these videos over. We got through about 50 out of the 70 questions. So we did pretty good. We realized there's 2 pages that we did miss. So we'll get Darren to do an audio on that, and then we'll get the rest of those out so that he's all caught up, and he delivered on what he promised. But for now, loved ones, we're going to check him out, and we'll get this video up for your reviewing pleasure as soon as possible.
Alrighty, loved ones. We'll see what we can do with getting that to you as soon as I can. Okay, everybody.
If you guys have more questions, just put them in the Telegram chat, and don't forget your hashtag question before. And yes, if whatever ones we did go over, we will pull them and Darren will go over them later.